If everybody will grab their seats, we have a quorum. We'll find out if we have a quorum. If I can count, I think we have a quorum, and we will get started for this third meeting of House Standing Committee on Licensing, Occupations, and Administrative Regulations. Please call the roll.
Representative Banta.
Here in the room.
Representative Bratcher. Representative Flannery.
Present. Annex office.
Thank you. Representative Gentry. Representative Huff.
Present in the room.
Representative Cook.
Here in the room.
Representative Massey.
Here in the room.
Representative McCoy.
Here.
Representative Meredith. Representative Miller.
Proudly present here.
Representative Moser. Representative Palumbo.
Here in my annex office.
Okay. Representative Pratt.
Present in the room.
Representative Santoro. Representative Timoney. Representative Westrom. Chairman Koenig.
Here. We have a quorum. We're duly constituted to do business. First up is House Bill 65. Representative Kirk McCormick. Come on down. I believe you're going to give some brief testimony. You have a special guest on Zoom who will also give some brief testimony, and we have an expert from CSG Online who's available to answer any questions. Is that right?
We do, yes.
All right. Please proceed.
I thank you, Mr. Chairman. Representative Norma Kirk McCormick, District 93. Today we bring before you an interstate compact bill on counseling, House Bill 65. This bill has to deal with interstate compact for licensed counselors. We are faced with a major shortage of counselors all throughout the nation, especially with COVID. We have a backlog of people waiting to receive counseling. And you may not know this, but every counselor or mental health profession has to be licensed in every state, and they have to pay a fee to keep up that licensing every year. So we live pretty much in a tri-state area. And it makes it difficult for counselors to see consumers that, for example, if they live in Ashland and practice in Huntington, or vice versa, or the clients are there. So,
Motion on the bill.
We have a motion and a second. I believe this is all the standard language that is used in most of the other compacts. Is that correct?
correct.
All right. I know you have a special guest, I believe a daughter-in-law.
Yes, Miss Lindsay Brown McCormick, Dr. Lindsay Brown McCormick lives coming to us from St. Clairsville, Ohio. She's also an associate professor at Chicago University.
Dr. Brown McCormick, would you like to say a few words? Although, we have a motion in a second and we hate to delay things, but since you took the time to join us, we'd love to hear from you for a minute.
Sure. I speak for myself both as a professor and a licensed professional clinical counselor within the state of Kentucky. I have 5 licenses to practice in 5 different states. And from a counselor's perspective, it's a lot to keep up with. But I also know in terms of a consumer perspective, last year I had a wait list of 6 months, and that's just unacceptable. And for people to be able to receive care and get care in a timely fashion, especially when they're in crisis, and something like an interstate compact would be phenomenal for that.
Thank you. I appreciate that. Any questions? Seeing none, please call the roll.
Representative Banta,
Yes.
Representative Bratcher,
Yes.
Representative Flannery,
Aye.
Representative Gentry,
Yes.
Representative Huff,
Yes.
Representative Cook,
Yes.
Representative Massey, Representative McCoy,
Yes.
Representative Meredith, Representative Miller,
Yes.
Representative Moser,
If I may explain my vote quickly.
Yes.
I am a yes, and I am very glad that you have brought this piece of legislation before us. This is critically important to keeping more licensed counselors in our state and improving access to care for our patients. So thank you.
Representative Palumbo,
Thank you, Dr. Brown McCormick. And my vote is, of course, yes.
Representative Pratt,
Yes.
Representative Santoro, Representative Timoney, Representative Westrom, Chairman Koenig.
Yes. Motion passes. That same should pass on the House floor. Congratulations and thank you.
Thank you.
Our next and final bill is House Bill 337, Representative Hale. Come on down, take your seat in the barrel, and the floor is yours.
Good morning, Mr. Chairman, and thank you this morning. I'm Representative David Hale. I certainly appreciate the opportunity today to be before you and this committee. If I'm not mistaken, I think this is my first appearance before this committee, so in 8 years of being here, I counted a privilege you've let me come to testify.
We added administrative regulations just so you'd have the opportunity
All right. Well,
to join the best and the brightest here in the House.
Well, having said that and hearing all of that, kind of no. Let me proceed just a moment, Representative Santoro. Since this is my first appearance, I want to make it a good one, hopefully, this morning. I do appreciate, really seriously, the opportunity, and thank you for hearing House Bill 337. I've got it right here in my hand. You probably have a copy. You see a 20-page bill there before you. That's certainly not 20 pages in complication. It really isn't. It's a pretty cut and dried bill. I hear people say all the time, "Well, this is just a simple bill." Well, this is not really just a simple bill, but it's certainly one that's kind of self-explanatory. Until a few years ago, when I became was appointed to be the co-chair of the Administrative Regulations Subcommittee on the House side, I'll be very frank, I had no idea, Mr. Chairman, how administrative regs worked. I really didn't know how that process worked. I didn't know what happened in that process. I didn't know how they were handled, how they were promulgated. And that was probably certainly my ignorance on that. But it being in that position, it has certainly been an eye-opening experience for me. And having served in that position with the past administration, the Bevin administration, and now also with the Beshear administration here, we see numerous, I'm literally hundreds and hundreds and hundreds of regulations come through our committees every year. But what I have also seen in both administrations is there has been attempts to seemingly get some of those regs through by bypassing the legislative process. And it happens quite frequently. But just real quickly, and I'm sure everybody in here knows that, but when a regulation that either comes before a standing committee or before the regulation review subcommittee, if by chance that regulation is found to be deficient by either one of those committees, the governor or the chief executive officer or the cabinet head or whomever that regulation has come through can go ahead and proceed with that regulation as though nothing has happened, even though it has been found deficient by the standing committee, the review subcommittee, and it just proceeds as if nothing has ever happened about that. But if House Bill 337 was to become law, any regulation that would be found deficient by either a standing committee or that review subcommittee would now be reported to the Attorney General and the Governor, both of them pursuant to KRS 13A-330. And the administrative body, the cabinet or whomever, then has the opportunity to appeal whatever that finding of deficiency may be within a period of time. I'm not going to read the whole bill. You can actually look at the bill. It gives you the exact specifications of what would happen. And on page 7, section 3, line 15, and over to line 6 on page 8, it gives a very explicit, simple definition as to what would occur if that process happened. So I want to close by saying this, and I know there's some people would say, and even I've received some emails from people that said this is just another power grab, but I would respectfully disagree with that. This measure, in my opinion, strengthens very much the checks and balances by granting this review to a third party who also happens to be the state's chief law enforcement officer. So this is not about taking power away from the governor or the administration, whomever that administration or that governor may be, but it brings us into this regulatory process, makes it far more accountable, in my opinion, by this piece of legislation. And I hope I haven't confused you this morning, but policies that we have like this, to me, they're going to stand the test of time long after we're all gone. This governor, the next governor's gone, the AG, whomever that might be. So, Mr. Chairman, that is my testimony this morning, and if there are any questions, I would be very glad to answer.
Very good. We have a motion from Representative McCoy, second from Representative Miller. We have Tom Fitzgerald online who would like to speak in opposition, but first, I would like to see if there's any questions for the sponsor. Representative Gentry.
Thank you, Mr. Chair. Representative Hill, I'm trying to get my mind around this for a second. If you could turn to page 17 on the bill, section 7. I know this is not highlighted, but it says KRS 45A is repealed and reacted to read as follows. And then when you move to page 19, let's see where I'm at. Page 19, line 4.
Yes, sir.
C. Has this been changed? Is this different than what was before? Because as I read this, I used to serve on government contract review. Is this process changed in any way? And if so, could you explain what the differences are?
Representative Gentry, I'm not exactly sure if I understand your question. When you say has it been changed from what, sir?
That's what I'm asking you. Is this I know it's not highlighted, but is what reads here different than?
Are you speaking basically on the appeal?
Yes.
Yes, sir. Well, the appeal, if in this particular piece of legislation, the appeal process there would be a 10-day appeal process by the administrative head or the governor's office or whomever that would be to, now under this piece of legislation, the Attorney General of the state of Kentucky.
Can I interrupt here for just a second?
Yes, and maybe, Mr. Chairman, I didn't quote that right, but
let Representative Cook take care of the answer to this question.
Yeah, Representative Gentry, on that page, so that let me turn back to it on page 17 there, where it says is repealed and reenacted as follows. That's a bill that I ran last year on government contract review. And so that I was making a bill because I'm having the same problem in government contract review with the process and trying to add a third party in there to do that, which was going to be the state treasurer. So what you're reading there that's language from a bill last year, and that involves a section 7 where we're working on 45A.
Which became law.
It did, and then
yes.
But then it was overturned. It went to court, and because of the process, and I'm currently working on that bill again right now.
Okay, gotcha. Does that answer your question, Representative Gentry?
So the answer is it has changed a little bit.
Yes.
And could I have a follow-up question?
Yeah, absolutely.
I'm even having trouble understanding this myself, and I'm a legislator. For the people at home that are watching, can we explain what the old process is and what the change is here? Because a lot of people that look at this, don't see bold material or bolded material and thinks that there is no change or is no difference. Does that make sense? I'm sorry.
Well, I mean, I'll be glad to try to answer that. I may be a little confused on what the question actually is, but in the House bill, or in this proposed bill that I'm bringing before you today, it just basically takes when a deficiency is found by either committee, it takes that to now go to the Attorney General of the state instead of just going directly to the administrative head, the administration itself, and the Attorney General now becomes a third party in that decision.
If I may tag on to that, Representative Hale, I believe where Representative Gentry's going is right now.
Yes, sir.
Regs are passed, as you know, and if you all in your committee found them deficient, then the governor can then either accept that and work on it, or just say, no, we think it's fine, and they go into effect anyway. The change that this bill is looking to do is, instead of the final decision going to the governor, the final decision will then go to a third party to look at it with a new set of eyes, and that third party is the Attorney General's office.
If I may add just
Correct?
yes, that is
Okay.
correct. And if I may add just one thing to that, Mr. Chairman, and to Representative Gentry, to be very frank, there are very few regulations that are found deficient. As a matter of fact, in 2021, we had almost 700 regulations come through the review subcommittee. I think the total was like 689 or something like that. But of that 689 and almost 700, there was actually 6 of those regs that were found deficient. So that's like 1%. And most of those regs that were found deficient, well, actually all of those 6, the administration went ahead and promulgated those regs, even though that they were found deficient by the committees. So this just adds a third party to this, the Attorney General, and I just, again, in my closing statement, I believe this just gives us more transparency in everything we're doing here. So, thank you.
Any further questions?
That is it for now.
Okay.
Thank you.
All right. Seeing no further questions for Representative Hale. I'm sorry, Representative Bratcher, you have a question. I apologize. Okay. All right. Mr. Fitzgerald.
Good morning,
Introduce
Mr.
yourself
Chairman.
for the record, and tell us all we need to know, and nothing more, if you would.
Absolutely, Mr. Chairman. Thank you. Tom Fitzgerald, formerly director, now just senior staff over at the Kentucky Resources Council. And Mr. Chairman, I'm going to tell the committee that I promised I would be uncharacteristically brief, and I will try to do so. I have not talked to the committee members, and I apologize for that, members of the committee, because I was only able to communicate my concerns to Representative Hale a couple of days ago. So out of respect for him, I did not attempt to communicate directly with committee members because I wanted to make sure he had those concerns first. My concerns essentially are twofold. One is that, as Representative Hale noted, the situations in which a committee, either the Administrative Reg Committee or the Committee of Jurisdiction, the second committee that reviews these regulations, has found a reg to be deficient is exceedingly rare. And so I question the necessity of the bill. The current process, I think, is absolutely sufficient to assure that in those rare instances in which there's a determination of deficiency by a committee, followed by a finding by the governor that the regulation should go into effect notwithstanding, the regulations can be addressed either through judicial challenge or through subsequent legislative action, as has been the case. Just to put a fine point on it, since 2000 until the current day, 25 regulations by my counting have been found to be deficient and have gone into effect notwithstanding. In most of those cases, the regulations are not deficient in the sense that they were promulgated without legal process. They were found deficient because there's a policy disagreement. For example, dealing with the degree to which non-coal mining operations should be regulated under the patent administration, the question of how rigorously industrial scale hog operations should be regulated, again, under the patent administration, the question of whether Medicaid should be expanded more recently. These are policy issues, not matters of the regulation not having followed the regulatory promulgation process. Since 2005, there have been 9,676 regular regulations promulgated. So we're looking at a bill that is addressing 0.2% of the regulations that have been adopted in the past 16, 17 years. And I question whether we should upend the current process to address such a minor problem that is, in fact, already redressed through access to the courts and through subsequent legislative action, because it takes many months to promulgate a regulation. And we are back here in Frankfurt, virtually or in person, every year. My second concern is that the attempt to delegate to the Office of the Attorney General the power to hear appeals of an executive branch agency decision regarding a regulation that is identified by an interim committee as being deficient runs afoul of the decision in LRC versus Brown, which visited the earlier legislative process regarding administrative regulations and found that the delegation to the Administrative Reg Committee the authority to determine a regulation to be ineffective due to a deficiency was an exceedance of the legislative function. It was an unlawful delegation to a committee of a legislative power. This bill, first, by attempting to delegate to the Attorney General's office the ability to review an interim committee finding a deficiency that would result potentially in the immediate invalidation of that regulation, violates the separation of powers as an unlawful delegation of legislative authority. If, as is the case, the General Assembly cannot act through an interim committee and directly invalidate a regulation without running afoul of LRC versus Brown and the separation of powers doctrine in the Constitution, it's equally the case that the interim committee cannot set in motion that invalidation by declaring that the regulation is void unless it's appealed to the Attorney General, who in turn can uphold that deficiency finding and cause the regulation to be invalidated. Additionally, the power to adopt regulations to implement statutes is an executive branch function by Constitution and cannot be delegated by the legislature to the Attorney General's office without running afoul of LRC versus Brown. But in effect, that's what the bill does. Finally, and perhaps most fundamentally, the determination of whether regulation comports with the statute, as noted by the court in LRC versus Brown, is a judicial function. And it's not one that can be assigned by the General Assembly to the Attorney General without encroaching on the judicial branch function, again, in violation of separation of powers. So I appreciate, Mr. Chairman, this is my 43rd year. 41 of them as director of the Resources Council, now as senior staff and soon to be fossilized, I think. But it is, I understand that there are occasional frustrations among the branches of government regarding administrative regulations that are thought to, for one reason or another, to exceed or be inconsistent with the legislative mandate. We have remedies for that. And the remedies that we have been tested and are in conformance with the hard separation of powers that our state constitution has in it. And I would encourage the committee, this is not a problem that needs fixing. It is, we're dealing with we're dealing with 0.24% of the regulations that have been adopted over the past 16 years, the thousands of regulations. And I would encourage the committee to consider whether, in fact, we need to upend this process and potentially run afoul of the Constitution in order to address an issue that is adequately addressed currently. So I appreciate that very much, Representative Hale. I'm sorry I wasn't able to get up to you earlier than this week. And Mr. Chairman, I'm happy to answer any questions that any of the members of the committee have. Thank you very much.
Thank you. Representative Bratcher, did you have a question?
A comment and a question, if you don't
Yes,
mind.
sir.
The comment is I want to thank Tom Fitzgerald for so many years. You know, when I came down here 100 years ago, you had already been here 100 before that. So, and there's several times we worked together, and sometimes we opposed each other. But there was, your straightforwardness was always appreciated. You were very transparent on everything, and I appreciate that. And the question is, Representative Hale, what is the recourse now? I mean, there's got to be some recourse if some regulation is so out of whack. Do they take it to court or something? I mean, what if the law says it shall be 1, 2, 3, and they come out with a reg that says it's going to be 4, 5, 6? I mean, and it's just a blatant mischaracterization of the intent of the law. What is the recourse now?
Well, of course, once that regulation is brought before whatever committee it would be brought before, or before the review subcommittee, if there would be, again, a deficiency finding of that reg could go ahead and be promulgated just as though it was not found deficient. Is there a recourse for us as the legislature?
Or anybody?
That would probably have to be a question that somebody in the legal mind would answer on that. I'm not exactly sure about that, Representative Bratcher. Again, I apologize. I really don't know the answer for that.
There is.
Mr. Chairman,
hold on, Tom.
Yeah, sure.
I think it's, and let me just say this, I, since becoming chairman of this committee, I dealt with 2 administrations of 2 different parties, and had issues with administrative regulations in both of them. And I've remedied them by meeting with staff from PPC, various departments, and fixed it that way. My direct ship cleanup bill last year was done in part because didn't like ABC regulations that came from it, and I think flew in the face of the intent of the legislation and the actual words written there. So, I mean, there's always plenty of remedies. This will be another one of the remedies. I would have preferred not to have to file a whole different bill to fix those on the direct ship bill, and this. Instead of using this committee to find those regs deficient, because they would have just been overturned by the governor and put into place anyway, chose to get the whole process started, allow people to start shipping, because that would have just slowed things up. Decided to just get it started and then deal with those in the next year. It would have been nice to have had the option of perhaps doing it this way. Going forward, and that's we have plenty of options before us, and this will be another one. And there are, and when talk of not a lot of regs are found deficient, that's sometimes because some of us chairs and other members of the body work it out with the administration in advance. So anyway, that's preferable.
Absolutely,
certainly.
Sir. That is,
and I'm sure you, as chairman of Administrative Reg Review, you probably do that more often than any of us.
We have had numerous regulations that we worked out. Instead of going through the deficiency process, we went back and met with the folks, worked those out, and for the most part, we were able to get those problems solved.
And hopefully, we will continue to do things
Yes, sir.
that way, and this will be a last-ditch effort. So,
Mr. Chairman, could I just add one thing? And Mr. Fitzgerald, I want to add this. He did reach out to me. He emailed me with his concerns and was very open and upfront about that. And Mr. Fitzgerald, I appreciate that very much. You're reaching out to me as the chairman of that, co-chair of that committee. So thank you very much, sir.
So
thank you, Mr. Chair.
anything further from the committee? We have a motion and a second. Please call the roll.
Representative Banta.
Yes.
Representative Bratcher.
Yes.
Representative Flannery.
Aye. Aye.
Representative Gentry.
No.
Representative Huff,
Yes.
Representative Cook,
Yes.
Representative Massey, Representative McCoy,
Yes.
Representative Meredith,
Yes.
Representative Miller, Representative Moser,
Yes.
Representative Palumbo,
May I please explain my vote?
Yes, ma'am.
In this 20-page bill, there is new language that mentions the Attorney General 33 times. This legislation is overreaching, unnecessary, and unconstitutional. I vote no.
Representative Pratt,
Yes.
Representative Santoro,
Yes.
Representative Timoney, Representative Westrom, Chairman Koenig.
Yes. We good? Motion passes. The same should pass on the House floor.
Thank you, Mr. Chairman. Members of the committee, I appreciate your time. And Mr. Chairman, thank you for letting me come this first time. If you'll find me a good horse racing bill, I'll be back.
Hey!
If it comes out of this committee, it's by definition good.
Good, Bill.
Mr. Chairman,
Yes, sir.
may I record a yes vote on House Bill number 65,
Absolutely. We would love that.
please? Thank you.
Having come to the end of the agenda, we will stand adjourned and we will see you all probably next week. Thank you.